Hello and welcome back to the another episode of Indian Polity Lectures. It is lecture number 7, I guess. Yeah, it is 7th lecture, not 6th lecture. 7th lecture today, and it is 11th June 2025. So before we will start our discussion, I would like to give the brief introduction about the initiative so that if you are first time watching this video, you would get connected with us. Basically every day from 2nd June, we started this initiative. Every day we are taking two classes here. In the first one, which is in the morning session, we discuss the daily news analysis. What we take here, we take up the most important articles from the newspapers, we discuss them, we break them down into the simplest language possible, and we discuss them in the perspective of mains as well as prelims, and finally we derive possible questions which could be asked from those articles. This is what we do in the first phase, in the morning session. In the evening or night session, we upload this video. In this we discuss the static syllabus. Why we are doing this? Because we had promised you that every day we will try to cover your static syllabus, and by the month of Jan 2026 we will try to complete your full syllabus. And we started with Indian polity. Right now we are discussing the fundamental rights in it. So this is the evening session which we discuss. We discuss the subjects, static subjects, and we started with Indian polity. And one more thing I would like to mention here, if you are watching this and you are interested in following us, you are interested in watching these videos, I would like to mention one thing, that while we are giving you the lectures, at the same time we are preparing notes for you which will be relevant with respect to prelims as well as mains, because we are containing both the conceptual side as well as the fact side of your syllabus. If you will read those notes, those notes will contain everything whether related to prelims or mains, so they would be overall whatever is required for your preparation. So if you are interested in buying those notes from us, you just have to mail us, and it will only cost 200 rupees per subject for those notes. For example, once we will complete the syllabus of Indian polity, the notes would be available, and you would just have to mail us, and you will be you would have to give only 200 rupees per subject, and we will give you the notes for these classes. If you are interested, please do contact us. If you are not interested in buying the notes, then at least watch the video, because in here we will try to cover everything what is required for you. So with this, let me rub it first and start our discussion. We started this initiative from the 2nd June, and we started with the simple discussion on what constitution is. Then we by the time we reached till the fundamental rights. In our last class we discussed article 12, how it defines the state. We discussed article 13, how it makes the laws which are inconsistent with the fundamental rights void. We discussed article 14. We discussed the concept of equality before law and equal opportunity of the law. We discussed that. And now equal protection of the law, we discussed that, what is equality before law and equal protection of the law. We discussed how they are very much different, how equality before the law we borrowed it from the UK constitution, and equal protection of the law we borrowed it from the US constitution. After discussing all that what was required in it, we discussed the questions which could be framed from these articles. Now today our discussion would revolve around article 16, article 17, article 18. So let's see what does article 17, article 16 say. Article 16, as you can see here, it says it is about the equality of opportunity in matters of the public employment. There are various clauses in article 16. It may take us some time to discuss it in a very proper way, but I will try my best to make it very much simple for you, so that you will not forget it and it would be very much understandable for you. So what does article 16 say? It is basically talking about the equality of opportunity in matters of public employment. So what is the clause 1 say? It says there shall be equality of opportunity for all citizens in matters relating to employment, or appointments to any office under the state. For example, if you want to get the employment, you want to get the appointment, there should be the equality of opportunity. It cannot be like that. For example, for you cracking the UPSC exam, for appearing for the UPSC exam, for certain people it can't be the graduation that you should have passed your graduation, and for certain people it can't be that you just have crossed the matriculation exams, we had just passed the matriculation exams. So there should be very much equality in it. There should be equal opportunity for everybody. But to whatever community you belong to, this opportunity should be there. Very simple to understand, very easy to remember. So what does the second clause says? It says, no citizen shall on grounds of only of religion, race, caste, sex, descent, place of birth, residence, or any of them be ineligible or discriminated against in respect of any employment or office under the state. Now this is something which we would want to discuss about. So what are the grounds on which you can't be discriminated? The grounds are religion, race, caste, sex, descent, place of birth, residence, or any of them. So are there only these grounds on which you cannot be discriminated? 100%. Under this article, on these grounds you can't be discriminated. What about merit? Suppose, and now let me give you this example again. Suppose you are appearing for UPSC and you did not crack your prelims, even your prelims exam. Or when you were filling the forms, you did not fill the form on the time. So can you go to the court now and tell them, sir, UPSC is discriminating against me, they are not appointing me as an IAS officer, as an IPS officer? Why? Because I belong to particular religion, I belong to particular race, I belong to particular sex. Because of this, I belong to particular descent, I belong to particular residence, I belong to Northeast, or I belong to Jammu and Kashmir. Can I say that the UPSC is biased towards me? No, we can't say that, because judiciary will slap us. The reason is that you had not filled the form. It was available to everyone. You had been given the opportunity, you did not fill the form. This can be the reason that you would not enter into the exam, or you had not cleared the prelims exam. If you are not clearing even the prelims exam, how you can ask the judiciary that, sir, they are discriminating against you? So for this, can there be other, as we are discussing it, clause 2, these are the cases in these are the grounds on which you can't be discriminated. But there can be other grounds. What are those grounds? Those grounds can be merit, those grounds can be age, those grounds can be discipline. You are entering into the exam hall and you are making the noises there, you are trying to cheat there. So these can be the other cases, these can be the other grounds on which you can be discriminated. So this is what the article 16 clause 2 says. Now what does the article 16 clause 3 says? Article 16 clause 3 says, nothing in this article shall prevent Parliament from making any law prescribing in regard to class or classes of employment or appointments to an office under the government or any local or other authority within a state or union territory, any requirement as to residence within the state or union territory prior to such employment or appointment. Very difficult to understand if we will see the language, but let me make it simple for you. What does the article section clause 3 says? It says that this article 16 clause 3 says it confers the power on the Parliament to provide by law the residence as a qualification in cases of certain classes of employment. You know what article section clause 3 says? Article section clause 3 says it gives the power that residence can be the reason of reservation in appointments in certain jobs. For example, I would say you need a peon in your home. What will you do? Would you call? Would you go and give the advertisement on the internet, or give the advertisement on the TV that anybody from the country is eligible for that for this job? And if you are living in Delhi, a person can book living in Tamil Nadu, he has to book the flights, he will come to the job, he will have to work there for 5 hours or 6 hours, then he has to go back. No, it seems ridiculous. Or even you, in your state only, in your district only, in your town only, what would you prefer? You would definitely prefer those people who are living nearby you. You will try to give these jobs who are living nearby you. That is exactly what Article 16.3 says. There are certain jobs, certain jobs which are low, low category jobs. If we will be very much, very much layman in our language, there are certain jobs which are low grade jobs. For those jobs you can give reservation, you can keep reservation particular to residents. If for example there are class 4 jobs, class 3 jobs, these jobs can be reserved for the people who are living in that particular state. So this is approved by what? It is approved by Article 16.3. Does it violate Article section clause 2? Here we saw that you can't discriminate against any person with respect to the residents, but here we are discriminating that anybody who is coming from far-flung area, he wants to work in your state, but you are giving reservation to particular people. No, it is not discrimination, because this is allowed under same article in clause 3. So this is what the article section clause 3 says. It gives reservation. Residence can be the reason of the reservation for certain kind of jobs or low grade jobs. So with respect to this, you would have heard about mulki rules, mulki rules during the Nizam era. During the Nizam era, when India got independence, Hyderabad merged with Indian Union. It was the princely state, and there the Nizam of the Hyderabad, he had this rule that there were certain jobs which were reserved for the people living in this particular area only. So what they did, they asked the government that after merging with India, they asked government that this should be extended for another 10 years. These jobs were for the lower class. They were lower class jobs for the residents of Hyderabad. They wanted to extend it for the 10 years, and they were allowed. So reservation was given in this particular region, in this particular area. And also you would have heard about Article 371J. You would have heard about Article 371J. What does it say? It talks about the Kalyan, Kalyan Karnataka region. It talks about the Kalyan Karnataka region. What is this Kalyan Karnataka region? Kalyan Karnataka region. What is this? It is the Hyderabad Karnataka. It was basically Hyderabad Karnataka region. If you belong in this region, in this Kalyan Karnataka region or Hyderabad Karnataka region, if you belong to certain districts, and they were notified 6 districts were there. If you belong to those certain 6 districts, for example Raichur, for example Bihar, if you belong to these certain districts, you will be given this opportunity. Your jobs would be reserved in these. If in these areas if you belong to these areas, there would be reservation on the basis of residence in this particular area. So this is what Article 16 clause 3 says. So with this, I hope you had understood Article 1, Article 16 clause 1, Article 16 clause 2, and Article 16 clause 3. Now let us shift towards the Article 16 clause 4. Before that, I will try to rub it so that we will make our screen very much clear here. Let me rub it first. Let's see what does the Article 16 clause 4 says. Article 16 clause 4 here says, nothing in this article shall prevent the state from making provisions for the reservation of appointment posts in favor of any backward class of citizens which in opinion of the state is not adequately represented in the services under the state. So what does the Article 16 clause 4 says? It says nothing in this article shall prevent the state from making any provision for the reservation of the appointment or posts in favor of any backward classes of citizens which in the opinion of the state are not adequately represented in the services under the state. So what does the Article 16 give? It gives the reservation. 16 clause 4, it gives reservation for whom? For for backward classes, especially SCs and STs. What does it say? It empowers state to reserve states seats for backward classes, especially SCs and STs, if these classes are not adequately are not adequately represented in the services, are not adequately represented in the services, then state can make this provision, they can give reservation to them. So here comes the question, is reservation a fundamental right? Suppose tomorrow, if suppose tomorrow state will not give you reservation, can you go to the court, sir, state is not giving us the reservation? No. Reservation is not a fundamental right. It is up to the government whether they want, it is up to the state whether they want to give it to you or not. It is up to them. It is not a fundamental right, that you have to understand. And here the article section clause 4 says it empowers the state to reserve seats for backward classes, SC and STs, if they are not adequately reserved in the services under the state. You know, because of this, now there was a confusion. What was the confusion? Is this backward classes which was mentioned in article clause 4, which was mentioned in clause 4, that backward classes of the citizens which in the opinion of the state are not adequately represented, is this backward class, does it only include SCs and STs, or there are some other also which we ignore? So there was discussion over it. What are these backward classes? Does it only include SCs and STs, or there are some other classes also? So for this, it was the year 1971. It was year 1977, sorry, not 71, 1977, when the Janata Party came into power. The Janata Party, they came into power, and what they did, they set up the commission. And what was the duty of the commission? They will, what was the duty of the commission? They will analyze the backward classes in our society, and they will try to find out, do we need to give them also reservation? Are SCs and STs only the socially and educationally backward, or there are still other classes which are socially and educationally backward? So this was given to the Mandal Commission, and it was headed by D.P. Mandal. This commission was headed by D.P. Mandal. So this commission, it worked on it. It did its studies, and it has found out, what did it found? The Mandal Commission found out that there are 52% of the population who are discriminated, who are socially and educationally backward. When the Mandal Commission gave its report, it highlighted that in our society there are 52% of the population, except SCs and STs, who are backward, and who are socially and educationally backward, and they need reservation. So what was decided, that 27% reservation should be given to whom? Should be given to the OBCs. Should be given to the OBCs. When they tried to implement it, unfortunately the government changed. They could not stand it, and in 1989 Congress came back, but it was the highest party, it was the most popular party, but was not that popular that it could make government of its own. So what happened, that VP Singh launched a campaign. VP Singh, it launched basically campaign against Congress. And what happened, the BJP government and VP Singh and the left parties, they combined and formed a government. So in 1989, this actually happened in 1989. This happened, that VP Singh formed the government with the help of BJP and left-wing parties, which were socialist parties. So when they formed the government, he decided, what the first thing the VP Singh decided, he decided to implement the Mandal Commission report, in which 27% reservation was to be given to OBC. So he gave this reservation, but at that time there was a political turmoil. BJP, they withdrew from them. They did not decide to stay with them because their motive was different. BJP's motive at that time was really different. They have different vision of politics, so they withdrew from it. But eventually, this reservation for the OBCs, it was finally decided. After the VP Singh, in the next election, the VP Singh, he lost the election, and who became the prime minister? It is Narasimha Rao, Narasimha Rao became the prime minister with the help of the and his finance minister was who? His finance minister was Dr. Manmohan Singh, late Dr. Manmohan Singh. So when they came into power, what decided? They decided that with OBC reservation, for OBC we are giving 27% reservation. We need to give reservation for economically backward, economically weaker sections too. For economically weaker sections too, and it was kept at 10%. So this thing, this article section 4, it basically talked about what reservation with respect to socially and economically backward sections. On this there was discussion whether SCs and STs only are the backward classes or there are still other backward classes. For that the Mandal Commission was created, which was headed by that Mandal, DP Mandal, and they gave the report that there are 52% of our population which is socially and educationally backward, and for them we need to give the reservation. And under this 27% reservation was decided by for OBC, but unfortunately the government changed. When the government changed, Congress could not Congress could not form the government. They were the largest party, but they could not form the government. And VP Singh, he was supported by BJP and left parties, and he decided that there should be 27% reservation for OBCs. And once he decided the 27% reservation for OBCs, the BJP withdrew its support because their major voters were from the higher, higher castes of the religion. So if this OBC reservation would be given, who would be the beneficiaries of OBC? They would be the lower castes of the Hindu religion. Majorly the lower castes would be the beneficiaries of OBC. So under this, it did not well went with the BJP. They withdrew it. Then the re-elections, and then there were again elections, and PV Narasimha Rao, he became the PM. And what he decided, he kept a 27% reservation for OBC, he kept a 15% reservation for SCs, he kept a 7.5% reservation for STs. With this, he decided to keep 10% reservation for the economically weaker sections. So with for this, he kept the 10% reservation for economically weaker section. So this case, when he kept this 10% reservation for economically weaker section, there were havoc in the society. How can you give this much reservation? As by general people, reservation is perceived that it is something wrong, it is something, it should not be given. So there were agitations that if such reservation would be given, who will get the job? Getting the job would be really difficult. And it was the time period when there was not that much boom of the private industries. Everything was dependent on what? Government jobs. Everybody was preparing for the government jobs. Everybody was dreaming of the government jobs. If at that time this much reservation was decided, so it did not went well with the people there that time, and they started agitation against it. And finally the case went to the court, and it was the Indra Sahani. First let me rub it, then we will take up the case. What was the case study here? So till now I hope article 16 clause 1, clause 2 and clause 3 are clear. We are discussing clause 4. In it, reservation for socially and educationally backward classes. Then decided who is the educational backward, socially and educational backward. Is it specific to SCs and STs, or there are some other? Mandal Commission was created for that, and Mandal Commission gave its report in which it highlighted that there are 52% population in our country who are socially and educationally backward, and they need reservation. For them 25% reservation in OBC. Then the government changed. Narasimha Rao came in. He extended the reservation, 10% reservation for economically weaker sections. When this much reservation was given, for example, I will again highlight it here. For SCs there is 15%. For STs there is 7.5%. For OBCs 27% was decided, and for economically weaker sections 10% was decided. So if we will calculate it, it is coming way higher. And now the case, there were agitations in the country. Students started protesting against it, and many students, they unfortunately killed themselves. They did suicide because they believed that they are not able to get the job under this. So the case went, there was a person, a lawyer, namely, what was his name? Indra Swani. Indra Sahani, what he did, he filed an PIL in the Supreme Court, and he challenged the reservation for OBCs and poor. What was challenged in the Indra Sahani judgment? Reservation for OBCs and poor. So under Article 16(4), what was the now let's try to understand what did the Supreme Court did with respect to this. Supreme Court, when this PIL was filed, the Supreme Court accepted it, and they set up the constitutional bench for that. Constitutional bench for this constitutional bench will decide, because this was the constitutional matter. According to Indra Sahni, it is unconstitutional to give the reservation to OBCs and EWS. There was a question was about these two reservations. So please remember that these two reservations, they were under the question. So according to Indra Sahni, it was unconstitutional. So there was a need to discuss it, and for that the constitutional bench was formed. In 1992, this case was delivered, and it decided that Article 16(2), the Supreme Court said that Article 16 Clause 4, what it is? It is an enabling clause. It is an enabling clause to reserve seats in favor of backward classes. But reservation, and in this judgment itself, the Supreme Court said that reservation, it can be given by the government, but it is not a fundamental right. So it was decided that a reservation, it can be given by the government, but it is not a fundamental right. First thing what was decided here, state may not give the reservation. It is something you cannot claim from the state. And it was highlighted that the OBC reservation, in this judgment, it was highlighted, there were two things about the OBC reservation. It was highlighted that it is very much constitutional, and about economically weaker sections, it was highlighted that it is unconstitutional. So let's discuss why OBC reservation is constitutional, provided you know why it is constitutional, and what are the criteria which you have to follow to give the reservation to OBCs. First, you have to prove that what are the criteria that you can give reservation to OBCs if you are giving. First, you have to prove that prove these castes are socially and educationally backward. You have to prove that these castes to which you are giving reservation under OBC, that they are socially and educationally backward. How you can prove it? You have set up a commission, and they will discuss over it. And second, with the same thing, you have to give that they are not arbitrarily decided. They are not choosing from randomly that this caste will be OBC. So if you are choosing any caste under OBC, prove that they are socially and economically, educationally backward. Not economically, but educationally. Then second thing which you have to prove is that prove that they are not adequately represented in administration. Not adequately represented in administration. You have to prove that they are not adequately represented in administration. If you can't prove it, then they can't be added. So for that, commission is created. And also there was third important point, the concept of creamy layer should apply on OBC. The concept of creamy layer should apply on OBC. What does this concept of creamy layer is? Let's try to understand it. For example, there is some caste under OBC, and they had achieved this success. For example, I belong to an OBC, suppose, and my parent is an IS officer, or my parent he is a big businessman, or my parent he is MP in some constituency, or my parent is a CM. So even though I belong to OBC, this I'm not, I have this opportunity to go to the schools, to the best schools of the state. I have this opportunity, I can afford the best coaching. I have this opportunity, I can go to the best colleges. So this is the creamy layer. What does the article, what does it say, what does the judgment say? It says the concept of creamy layer should apply on OBCs. So what are the criteria you have to look into? First, if you are holding constitutional post, you are part of the creamy layer and can't get the benefit. If your net earning is above 8 lakh, your parent income is above 8 lakh, then you can't get the benefit. And you own the agricultural land more than 5 acres, you can't get the benefit. And in municipality area, you have the property which is spread over 100 or 1000 kilometers, and then you can't get the benefit. And also one more thing which was highlighted in this. So what does it say? It says OBC is very much constitutional, but you have to look out for these things. First, you have to look for whether what cost you are adding into it, OBC. You have to check for whether they are socially and educationally backward. Second, you have to check whether they are adequately represented or not. Then if they are not adequately represented, they are socially and educationally backward, then the third thing which you have to check is whether they belong to the creamy layer or not. So this was decided. It is for OBCs only. So please remember that the concept of this may be asked in the exam about the concept of creamy layer. It is particular to OBCs. It is not particular to SCs and STs here for the appointment purpose. For the promotion purpose, this may be discussed with respect to SCs and STs. So these were the criterias. Then what should be the overall reservation kept? The overall reservation, it should be below or equal to 50%. Overall reservation should not exceed 50%. You have to calculate that. In this way you should make up the reservation. And also one more thing, once you are giving the reservation, merit should be withheld. You can't compromise on merit. So these things you have to look after. If once you are going. Sorry, I had an important call. Where we had reached, we were discussing the Indra Sahni judgment. We were discussing, and we reached that what are the criteria which were kept for the OBC reservation. How it was made. It is constitutional, but you have to look for few criteria in it. First, you have to prove that the costs you are adding, they are not socially and educationally backward. Second, they are not adequately represented, and they don't belong to the creamy layer. Then one more thing, the overall reservation can't exceed the 50% limit, and also merit should not be compromised. At any cost, the merit should not be compromised. What does this mean, that merit should not be compromised? Let's try to discuss it through this example which I will highlight here. Very simple example, you will understand it. For example, you have to appear for UPSC. What is the requirement for UPSC? What is the requirement for the UPSC? The basic requirement which talks about the merit is that you need to be the graduate. At any cost, you should be the graduate. So what is the criteria that you need to be? First, let me rub it. You need to be the graduate to appear in the UPSC exam. Can we give the reservation like this, that for the general they have to be the graduate, and for the OBCs or SCs and STs they have to be what? They can be undergraduate or just matriculate. They had just cleared their matric exams. Can it be? No. It will evade the merit. It will impact the merit. So merit should be always respected. Merit, you have to always respect the merit. Merit can't be compromised. Under it, merit can't be compromised. They are both the parties, whether belonging to general or OBCs or any caste, they should be graduate. And here what we can do for the general, they will have the upper limit of the marks for upper cutoff, and for OBCs and others they will have slightly lower cutoff. But the basic qualification, what is needed for that would be very much similar for everybody. So this is what merit says. This is what it says, that merit can't be compromised. And one thing we understood that about the creamy layer, it is for OBCs, only for OBCs. And another thing we understood that during one important thing we understood in it, Concept of creamy layer should apply to OBCs, and we discussed that. Overall reservation can't exceed 50% except in earlier ordinary circumstances. We discussed that. Merit should not be compromised. We discussed that. Reservation only at the top of recruitment, not at the promotion. It was also discussed that reservation at the time of recruitment, during that time it can be given, but not at promotion. So this was highlighted in the Indra Sahni judgment. During the time of the Indra Sahni judgment, it was highlighted, for the appointment you can give the reservation, but not for the promotion. There you can't give the reservation. And also this 10% reservation which was given by Narasimha Rao government, it was made unconstitutional. It was made unconstitutional. Why? Because it was highlighted that the reservation, it is something which what we had historically done wrong, we are going to correct them, and giving it to the making it economic in nature. About economy, it is very much, economy is something which can fluctuate. Today you can be poor, tomorrow you can be very good. It may depend on the monsoon. So it was made unconstitutional. 10% reservation to poor, unconstitutional it was made. So this was the case of Indra Sahni judgment, or we can say famously known as Mandal case. So Parliament, after this Parliament got together and they came up with the Constitutional Amendment Act of 77th Constitutional Amendment Act in the year 1995. So what was the criteria kept in this Constitutional Amendment Act? Reservation in promotions for SCs and STs in public employment. If you belong to SC and ST, reservation can be given in the public employment. So what is the criteria? If they are not adequately represented, and then it is under the Constitutional Amendment Act of 77th Constitutional Amendment Act. What does it say? That reservation can be given to SCs and STs during the promotion also, but what is the criteria? If they are not adequately represented. Then came the case which is known as M. Nagaraj versus Union of India 2006. Now let me first drop it, then we will discuss that case, which is M. Nagaraj versus Union of India 2006. Let me regroup what we discussed. We saw that in Indra Sahni judgment, that there was one criteria mentioned. What was that criteria? That reservation only at appointment, but not at promotion. So with respect to this, the Parliament came together and they came up with the 77th Constitutional Amendment Act. In the 77th Constitutional Amendment Act, they highlight that reservation in promotions for SCs and STs in public employment. They gave this authority to the Parliament that they can give the reservation to SCs and STs in public employment, in promotions, in public appointments. So what if reason, if they are not adequately represented, so this was challenged in the Nagaraj versus Union of India. So what were the in the Nagaraj versus Union of India case, Nagaraj versus Union of India case, and 2006, this was also upheld by the courts. It was very much constitutional, but you have to prove something. What you have to prove? First, prove to us that SCs and STs are socially and educationally backward. First, to prove that SCs and STs are socially and educationally backward. Earlier we saw that in the Indra Sahni case, there we have to prove that the OBCs, the castes we add in there, they are socially and educationally backward. But here, for the promotion purpose, we are giving reservation to them through the 77th Constitutional Amendment Act. So now It was challenged, it was made constitutional, but there were few conditions. We have to prove that they are SCs and STs. The parliament has proved that these are socially and educationally backward. Second thing, they have to they are not adequately represented in the public employment. They are not adequately represented in the public employment. Then the third, does not affect the efficiency. The third, does not affect the efficiency. If these three criteria are followed, then you can give reservation to SCs and STs during promotion also. Then comes the turn for the Jarnail Singh versus the Lachnavi Narayan Gupta case 2018. So let's discuss what this case was about. Let's try to understand that what this case is about. Jarnail Singh versus L. Narayan Gupta case 2018. Jarnail Singh versus L. Narayan Gupta case 2018. So in this, what was decided in this case, suppose if you are promoting anybody from SCs or STs, there what you should apply, the concept of creamy layer. Apply the concept of creamy layer. If it follows there, then give them the promotion. If it does not follow there, then don't give them the promotion. Similarly, after that, there is the another case which is relevant right now. It is Mukesh Kumar versus the state of Uttarakhand. Mukesh Kumar versus state of Uttarakhand. So what is the story behind this case? They came up with the application for the government jobs. The advertisement for the government jobs. They came up with the advertisement for the government jobs, and they had highlighted there. What they highlight, that if you belong to SCs and STs and during promotion, you can't be given the reservation because of this. During promotion, they are not eligible for the reservation. No reservation in promotion for SCs and STs. It was highlighted in the notification. So this case went to the High Court of Uttarakhand. What High Court of Uttarakhand said, that they give us the data, prove us they are adequately represented. High Court said, prove us that if you are not giving the reservation to them during promotion, prove us that SCs and STs there are adequately represented, and they are not socially and educationally backward. Prove us these things. It did not went well with the Uttarakhand government. They appealed in the Supreme Court. They asked the Supreme Court, sir, they are asking us for the data. What should we do? Supreme Court said, what is the case here? They said that we notified the applications for certain job in which we did not give the reservation to SCs and STs for promotion, and now Uttarakhand government is asking us for the data. Supreme Court said that there is no need to give the data because it is reservation. It is not a fundamental right, and if you don't want to give the reservation, nobody can force you to give the reservation. Neither the High Court can force you, neither the Supreme Court can force you to give the reservation. You are right. If you don't want to give it, then it is up to you. So here also this was established that the reservation with respect to what? Reservation with respect to the if we compare it, is it a fundamental right? No, it is not a fundamental right. It is not enforceable. You can't go to the court and tell them, sir, government is not giving me the reservation to our cost. Supreme Court courts can't do anything to this. It is totally kept with what? It is totally kept with the state. So similarly, then the Maratha reservation, the topic of the Maratha reservation is there. They gave the Maratha government they gave the reservation to the Marathas in OBC category. How can you provide, set up, they set up the commission and it will evaluate it in November 2018. They were given the reservation. Socially and educationally backward act was passed by the Maratha. Bombay High Court said, the case went to the Bombay High Court, and what does it said? It upheld the reservation. Maratha, for the Maratha reservation, 16% was kept, 16% reservation to them, because they belong to OBCs, socially and educationally backward. And case went to the Bombay High Court. What they did, Bombay High Court withheld the reservation, and it said that for the employment purpose it should be 13%, and for the educational purpose for the education it should be 12%. It reduced the limit, but it upheld the reservation. The same thing went to the Supreme Court. What Supreme Court did? Supreme Court stayed the order, stayed the implementation of it, and in May 2021 Supreme Court said it is unconstitutional. What were the reasons that Marathas were not given the reservation? That we will discuss after I will rub the board here. After I will rub the board, we will discuss why Marathas were not given the reservation. As Maratha government gave reservation, they formed the act for that. 16% was decided. Case went to the Bombay High Court. Bombay High Court upheld the act, upheld the reservation, but the limit was reduced, which was kept to 16. It was reduced to 13 and 12. The case went to the Supreme Court. Initially, Supreme Court stayed the order. Then it said that it is unconstitutional. And what is the reason for Marathas not being given the reservation? For Marathas, why they were not given the reservation? It was said, who were the Marathas? They were basically the Dabbawalas. Dabbawalas. They were those who will prepare food for you. And if we will look at the discrimination, the untouchability, the caste discrimination in our country, if the impure blood will cook food for you, that would not be accepted. So socially, these people were cooking food, they were giving food to the people, so they were socially accepted, so they belong to the higher castes. And also about the Marathas, if we look at their political strength in the state, they are those who are forming the government there. They have this political dominance in their state, and also they enjoy the economic dominance. So this reservation for the Marathas, it was reduced, it was it was made unconstitutional. Now there comes the another question. What is the question? For example, there are 1,000 jobs created by UPSC, 500 for general and 500 for for reserved. Suppose general everybody applied, and in 500 only 400 seats got filled, because there were not enough candidates who could appear in this exam. So what are left? 100 seats are left. Now what will happen to these seats? Will these seats expire, or will it be carried further? So matter with respect to this, will these 100 seats they be will they get dissolved, or it will move? It will be carried forward. So this matter went to the court. It was decided that it should be disqualified. It can impact the efficiency. It would reduce the efficiency if it would be kept there. But SC said it will be eligible. Further, SC gave the judgment that these 100 seats, they would be there for further 3 years. Further 3 years it would be there. It won't get diluted. For 3 years it won't get diluted, and after that it will be merged. After that the constitution got amended again. 81st Constitutional Amendment Act came in the year 2000, and what was decided that it was the carry forward of these seats to n number of years. So unlimited number of years. This is Article 16B. Article 16(4)(b) came in, right? And it was decided that these number of seats, which will, by Supreme Court's decision, these numbers should be carried forward for 3 years. But the Parliament made the law. They amended the Constitution, and they came up that it should be carried out for the n number of years. So this is about the Article 16(4) Clause B, subclause B. Now let's discuss Article 16 clause Article 16 clause 5. What does it say? Article 16 clause 5, it basically talks about the can the religion be the ground for the reservation in particular jobs? Can it be the ground for the reservation? Yes, exactly, 100% it can be the ground for the reservation for particular jobs. For example, earlier we had the Waqf bill, which was recently amended. Let's see what will happen with that. With respect to Waqf bill, it is the property of the Muslims, which Muslims give it to the God, and it could be used for the welfare of the Muslims. There we have the Waqf board. It according to Article 15, Article 16.5, if you need officers for this Waqf board, they can be Muslims. So similarly, if there are other offices which are particular to the management of any board with respect to any religion, you can make laws, you can make employment with respect to that particular religion. For example, you need IAS officer or any officer in the board or anywhere else. You can do this if it is particular to that religion. So what does it say? There can be discrimination on the ground of religion if you need to appoint somebody to the office and is about managing the affairs of that body, then job is given to them. Job can be given to that particular religion. Then as we discussed with respect to work board, how there used to be the members, the board members used to be Muslims, but it got amended. Now let's see what will happen to it. Definitely it will go to the courts. It already is in the courts. So let's discuss that when the final solution would be given with respect to that. After that, it is Article 16, Clause 5. So this is also clear. Now we are left with Article 16, Clause 6, which is the last article with respect to it, with last concept related to this article. Article 16 Clause 6 says that it was introduced by the 103rd Constitutional Amendment Act in 2020. What does it say? It talks about the economically weaker section reservation for economically weaker sections, and what was the limit? It was 10%. So what is the difference between the Narasimha Rao? We discussed that Narasimha Rao also tried to give 10% reservation, but it was made unconstitutional by the Indira Sahni judgment. What is the difference? That was an executive order, but here the constitution was amended. So that is the difference here. Constitution was amended, so it stood the ground fast. Now with respect to this, what is this EVS reservation that we have to understand? What does this EVS reservation talk about? Let's try to understand that, and then we will shift our focus to Article 17, 18 and 19. First we will discuss what is this EVS reservation. Suppose you belong to suppose you belong to the economically weaker section. Your annual income is less than 8 lakh rupees. You don't have the agricultural land. You don't have the you don't have the property in the municipality area, and you don't belong to any your parents were not government officials, A grade officials, or your parents, or you are not the ex MLAs or something like that. So you belong to an economically weaker sections. So this EWS, economically weaker sections, what they are, they are actually from the general category. So it was very much clearly noted that this EWS, they should not belong to the other costs or other categories in which this reservation is already given. For example, we have SCs, we have STs, we have OBCs, we have these. In this we have the reservation of 15%, we have 7.5%, we have 27% reservation. We have these reservation. If you want to get the reservation under EWS, economically weaker sections, and you are OBC, can you get the reservation? No, you cannot get the reservation if you belong to OBC or any of the above categories, or SCs or STs, and you can't demand then the reservation for what? You can't demand the reservation for EWS, because it is very much very well defined there. It is basically for the general category. Only those from the general category who are less in income, they can, they can get the benefit of this reservation. Not those who belong to SCs, STs or OBCs, they can't get the benefit of this reservation. Even if they are poor, they can't get the benefit of this reservation. So what was the biggest advantage of it? Biggest advantage of EWS reservation, it was religion neutral. Anybody can get the benefit of it. If we look at SCs, STs and OBCs, who are these people? They are majorly Hindus. And EWS, anybody can get it. They can be Hindu, they can be Muslim, they can be Parsi, they can be Sikh, anybody. So it is religion neutral, and it is recognizing the economic criteria, which is the real problem of the present time. Is economic division in our society. There is economic division. It is said that it is bigger division than the caste division. If you, in present world, what your prestige is recognized by the money you have. If you have the good amount of money, you would be respected, you would be given favors, you would be given loans by the government. And if you don't have these economical advantage, then you will be degraded in the society. So it is said that this economic class, now this caste division which used to be earlier, it has shifted to the class division now, and this class is decided by to which what your income criteria is. It decides whether what your cost will be or what your cost is. So these were the things which were highlighted, that if you belong to these castes, you can't get you can't be given this reservation, you can't be eligible for the EWS. Then matter went to the court, as it was believed that it is violating the it is very much against the principle of equality. So matter went to the court under the Janhit Abhiyan versus Union of India 2023. Janhit Abhiyan versus Union of India. So matter went to the court with respect to 103rd Constitutional Amendment Act, with respect to EWS, whether it is constitutional or not. So what does the court say? What were the questions which were raised? Can reservation be granted solely on the basis of economic criteria? The first question was asked, can reservation be granted solely on the basis of economic criteria? Yes. Second, can SCs, STs, OBCs and socially and economically backward classes be also eligible for EWS? The answer to this was no, they can't be eligible for it. And third question, can EWS breach the 50% 50% limit which was given us by the Indra Sahni judgment? And the answer to it was given by the various this case was heard by the 5-judge bench, and the 3 judges said that no, it is not breaching the principle, it is not breaching the limit given by the Indra Sahni judgment. Now let's try to understand what were the arguments which were given in favor of it and what were the arguments which are against it. So let's try to understand that. The arguments which are in favor of it, first, as we discussed, it is very much religion neutral. Second, it recognizes the existing reality, which is economic backwardness. Then this EWS reservation, it tries to provide opportunities for upward social mobility. It provides this opportunity, and also it constitution can't remain static. These were a few points which were highlighted, which are in agreement with it. First, religious neutrality. Second, recognizes the existing challenges, income inequality which is in our country. Third, EWS reservation tries to provide opportunity for upward social mobility. And the fourth one was constitution can't be static, we need to change it by the need of the time. Constitution can't be static. So these were the 4 things which are in favor of it. And what is the argument against it? Argument against it is reservation is not a poverty. First thing what was highlighted, that reservation is not a poverty elevation. But what is reservation? It is to write our wrongs, what we had to write our historic wrongs, what wrongs we had done in history, to write them, to correct those wrongs. But reservation, it is not a poverty elevation. If you want to help the poor people, give them scholarships, give them pensions, bring in schemes for them, but you can't bring the reservation for, you can't say that reservation is the reason that you want to uplift the people. Then also the second thing which was highlighted, which is against it, look at the criteria what is required for you to be be under EWS. First, your annual income should be less than 8 lakh, 5 acres of agricultural land, less than 1000 square kilometers property in the urban area. And according to the argument, it is something which is fluctuating. It is something which fluctuates. It is today and it may not be tomorrow. You may earn 8 lakh today, you may earn 2 lakhs today. Tomorrow, if the agriculture was good, you may earn 10 lakhs too. So it is something fluctuating. You cannot give reservation on this thing, on this thing which is fluctuating. Then the third point which was highlighted, the taxpayers in our country, 100% people will pay tax, indirect taxes, and about direct taxes only 2% pays the direct tax. Then we have to give reservation to approximately 98%. And if we have to give the reservation to the 98% people of our country, then it can't be the criteria for the reservation, because if it is above 95%, then you can't follow, this criteria can't be followed, that we need to give, they are marginalized, we need to give them the reservation. So these were few points which were highlighted in the judgment, and finally it was agreed that the judgment came in 3:2 ratio, that the EVS, economically weaker sections, for them 10% reservation is very much constitutional. So there were arguments between the judges with respect to the whether this is constitutional or not. In the Justice UU Lalit, the Justice UU Lalit was the CGI of India, and many questions were raised. For example, is it constitutional? Everybody said yes. Does it violate the basic feature? It was another question. Does it violate the basic feature? Three judges said no. 2 judges said yes. Why they said yes? Because they believe that if there is divide, what is the divide? It is for general only, and OBCs, SCs and STs are left out. There are poor people in these categories too who are not getting the benefit. So it is definitely the divide. You are benefiting one category and not others. So this was also the question here, which was answered. Then another question, does it violate the right to equality? 3 judges said no. 2 judges said yes, it does violate the right to equality. Then the another question which was discussed about the about our nature of our nature of society. Do we provide reservation to groups, or do we provide reservation to individuals? Is our society based on, is our policies based on the group subordinate theory or the color blind vision of equality? That is, do we focus on the individual or we focus on the groups? Basically we focus on the groups, but it is the it is the judgment, it is the Supreme Court judgment that our focus is basically on the groups. So if we will see in the state Kerala versus the NM Thomas case, it is circumstances decide the choice of the government. Like should be treated like. For example, it was highlighted that our criteria is to look for the groups rather than individuality. But if we are giving reservation under EWS, we are much focusing on the individuals than the groups. So these were few points which were highlighted in it. So at the end, in nutshell, Article 3, Article 15, Section Clause 6, it was made constitutional. It withheld the EWS, the educationally weaker sections. They were given reservation, 10% reservation. And the question, does it violate the Indra Sahni judgment? No, it does not violate that. So this is the discussion about the Article 15. Now here you need to understand few commissions. For example, the Kalelkar Commission, when it was set up, it was basically set up to discuss the backward classes. What should be the criteria that you need to know, and also the Mandal Commission, what by the criteria is decided by them, that you need to know. So about the Kalelkar Commission, it was set up in 1953. Aligarh Commission set up in 1953. And what were the criteria? It identified six criteria. What are these? First, traditional occupation and profession. What is the tradition, occupation, and profession of the people? For example, there are barbers. Their fathers are barbers, so they had developed their caste on this basis. So this was one of the criteria. Second, what is the literacy rate in that particular caste? What is the population of that particular caste? Then where distributed, in which areas they are distributed and concentrated? What is their social position? And how they are represented in the government services or the industrial sphere, how they are represented there. Similarly, then came the Mandal Commission. They came up with the 11 indicators, and they divided Mandal Commission divided these 11 indicators into three sets: social, educational, and the political. For example, what are the classes considered backward by others, in which schools they had studied, had they completed their matriculation, they what is the dropout rate, and also the political criteria was discussed there. So this was highlighted in the Mandal Commission that 52% in our area are backward. After that, we had seen that how Bihar came up with their cost survey, and they showed that 85% of our population is backward, and they gave the reservation, and they provide the reservation for the 65%. And the case went to the Supreme Court, and SC stayed it too. Then we have the case of the Tamil Nadu. They gave the 67% reservation, but they kept it in the 9th schedule. It violated the Indira Sahni judgment of 50%, but still it is going on, and it is in the courts. There is discussion over it. Can it violated the Indira Sahni judgment? Can it violate the basic structure? And can you make the law which will violate the basic structure and you will put it in the 9th schedule? No, you can't do that. So this was about the Article 16. All the clauses, I guess we had discussed in a very detailed manner. I hope there is no confusion. If there is any confusion, please do write in the comments. I will try my best to clear that confusion. Now let's try to understand the horizontal reservation. What this horizontal reservation is. In a few minutes we will try to understand it, and then we will shift to the Article 17. What does the Article 17 say? Here let's try to understand the horizontal relation. Suppose you are giving the reservation to OBCs, and in OBCs there are many costs. There are, for example, there would be some costs they will enjoy then there would be another cost they will enjoy certain percentage of reservation. Then there would be certain costs they will enjoy, and there would be many costs, and there would be few costs which would feel marginalized. So this horizontal reservation, what does it say? That it talks about the subclassification of the subclassification of the OBCs. And this was earlier done by the West Bengal, as they came up with the reservation to Muslims. Then Karnataka, Tamil Nadu government, and Andhra Pradesh. The case went to the Supreme Court, and they were asked a few questions. What were the questions? They asked that our reservation is not communal based. We have to give reservation to OBCs. OBCs can be any caste. Muslims can belong to OBCs. Earlier, Islam, if you know about it, believes in absolute equality. But we had seen when Islam came to India, it got indigenized. They have also the categories in the they have the caste categories, and there are some castes which are not that well established. So for them we need to give the reservation. We are not giving reservation to full Muslims, but to those particular castes we are giving the reservation. So this is the subclassification of OBCs, and this is with respect to the Muslims. And similarly, it was there was the Rohini Commission was set up for subclassification of OBCs. When it will come up with the report, we will definitely discuss that also. Then the last part with respect to this is the state of Punjab versus Devinder Singh 2024, in which, in nutshell, I would say, in this it was finally decided that the states can go for the subclassification of reservation in SCs and STs. The states can do it. So this was the final result under the state of Punjab versus Devinder Singh case 2024. It was decided last year. So with this, I guess Article 14 is very much clear. I hope we had covered everything what is important for you for your preparation. This much information. If you had understood, there should be nothing in the article if asked that you cannot answer that. Everything. If anything asked about Article 16, you should be ready to answer that question, because we had covered it in a very detailed manner. Now let us see what can be the preliminary question which can be asked from this question, from this article. The question says, which of the following statements about Article 16 of the Indian Constitution are correct? First statement, it guarantees equality of opportunities in matters of public employment. Correct. Second, it allows for reservation in appointments or posts in favor of any backward classes of citizens, which in the opinion of the state is not adequately represented in the services under the state. Correct. Third, it prohibits discrimination on the grounds of religion, race, sex, caste, descent, place of residence, or any of them in respect of any employment or office under the state. Correct. It allows for making any provision for the reservation of appointment or post in favor of any economically weaker sections of citizens, which is 15 subclause C, brought EWS under 103rd Constitutional Amendment Act. That is also true. So with this, if anything can be asked with respect to Article 16, I guess you are more mature enough to answer that question. Now coming back, let us shift our approach now to the Article 17. To the Article 17, let's try to understand that. What does the Article 17 say? What it is about? Let's try to find that out. Let's take a 2-minute break here. Then we will start again. Yeah, now discuss Article 17. What does the Article 17 say? We had seen in our history that there were few castes, as we were discussing the reservation. We had seen there were few castes where they were not even allowed to walk on the roads where the upper caste people will walk on. They were not allowed to touch the people of the upper caste. Their shadow was not allowed to fall on the people of upper caste. So there was huge discrimination in our society. So when the constitution was formed, it was made very much clear that everybody should be equal in our society. And it was the necessity that this thing should be addressed in the constitution. And in the constitution, in the fundamental rights, this is the only right which is absolute, it can't be negated. It can't be negated, because the reasons are very much clear. You cannot discriminate against anyone. You can't discriminate through actions, through your speech, or through anything. You would be held liable under the Atrocities Act. So let's try to understand what this Article 17 says. Basically, the principle of Article 17, it says the abolition of untouchability. What does the text say? It says the untouchability is abolished, and its practice in any form is forbidden. Is abolished, and it is practice in any form is prohibited. If you can see here, if you can note that is untouchability, it is kept in quotes, or we can say it is kept in inverted commas. So what does this untouchability say? It is not particularly defined, but it definitely, it definitely, it is, it definitely does not mean it is literal meaning. It is not confined to it is literal meaning. It is not confined to it is literal meaning. It is not defined, but it is not confined to the literal meaning. We had seen, we can see it is under quotes. So it definitely talks about the historic perspective of the untouchability, how it was done, how its practice was followed. So this is the whole ideology. The untouchability in itself is an ideology which was followed by the elites or higher castes, which was used, this was used to downgrade, to discriminate the people of the lower castes. So about untouchability, it does not mean the literal meaning. Why it does not mean the literal meaning? Because untouchability, you cannot, it even it is absolute, so you cannot give it the literal meaning. Suppose for example, we saw in 2020 onwards, there was the boom of COVID-19. For that, we were the patients, the people who had the symptoms of the COVID-19, they were supposed to be kept under quarantine. They had been, they have to move away from their family. They were not allowed to touch, handshakes were not allowed. So we can't say that it has the literal meaning. This was the need of the time. This untouchability, it was the need of the time, it was the requirement of the time. That is why we say that it does not mean the literal meaning, but it means it says it is that the practice which was followed in the India post-Vedic, in the post-Vedic era, how this practice was followed. So similarly with the case of leprosy, how leprosy, how the people are isolated so that this infection may not spread to the other people. So this article 17, it talks about the abolition of untouchability. Even the president cannot perform this. Even the president cannot do it. If he does it, he will be liable to impeachment. He can be impeached as he is violating the constitution. So let's try to understand what are the means of untouchability. Suppose you are refused, you belong to any particular caste, on any lower caste, and you are refused to get admission in any college, because you belong to that particular caste, then it will come under the untouchability. It will come under untouchability. Similarly, somebody is insulting you because of your caste, because of because of the historic this historic thing which you had with you, this historic perspective which you have with you, the lower caste perspective, lower caste understanding which you have with you. If you are insulted for that, you will be held accountable for it. If you are preaching the untouchability, if you are preaching this untouchability, then you would be held for it. And if you are justifying the untouchability, not only you are performing it, you are preaching it, you are insulting, you are not insulting, you are not harming anybody by hand, but you are insulting it, you are preaching, you are justifying it, then what? You would be held responsible for the untouchability, and you would be held under what? You will be held under Atrocities Act. And if you are held under Atrocities Act, then think your career is over, because about Atrocities Act, there is one thing which you should note, that the burden of proof is on accused. Usually what happens when, for example, you are framed for any crime, there is an allegation against you that you had done theft, or you had done murder, or you had done any severe crime like that. For such crimes, the burden of proof is on the prosecutor. The burden of proof is not on you. Burden of proof is on those who are holding you accountable. But with respect to the Atrocities Act, the burden of proof is on the accused. You have to prove that you are innocent under this Article 17. If you are caught under the Atrocities Act, if you had done any harm to the people, if you had done any kind of the act of untouchability, you are dealt under atrocities act, then what will happen? You have to prove that you are innocent, and this thing may take time. You may end up in jails for 8 to 9 years. So this burden of proof is on you. So with respect to this, we had seen various cases with respect to it, in which Dalits were beaten and the case went to the courts and they were held under it. So with this, there are high chances, even though this case respected the lower caste people, it gave them this protection against the untouchability, but at the same time, this law, this atrocities act, it was highly what misused. It was highly misused. It was highly misused. So the case went to the court. It went to the court, and it went to the court, and there was discussion that it should be neutralized, or in a way there should be protection given to the people who are misusing it. So what does the court ask? Court asked for the data. Give us the data. Why you are saying that it is being misused? What was the data highlighted? That look at the convention rate under the atrocities act, and we can see by the convention rate, we can see that approximately 80% of the cases are false. They are nullified. 80% of the cases are nullified. So in the Subhash Mahajan case, in the Subhash Mahajan case, August 2018, the Supreme Court decided that what does the Supreme Court decided? They decided that if such case, if any such case with respect to the atrocities act would come to the police should do first, before filing the FIR, what they should do? They should first do their initial investigation. They should police shall conduct the preliminary inquiry first. After they believe that the person, the Dalit person or the lower caste person or the accused or the oppressed person, he is telling the truth, then they should ask the permission from the higher police officials, DSPs or SP of such ranks. They should ask the permission from them, and once the permission is granted, then they can arrest the person who is accused. So this did not went well with the people. Many people did the protest against this judgment of the Supreme Court. They believe that Supreme Court has diluted the law meant to protect the SCs and STs. Many believed that, and the reason they highlight that if the convention rate is so low, the reason for that is, look at the police in our country. Most of the police officers in our country, they belong to the higher castes, and they make such cases, they make them so low that they did not stand the further investigation. That is why there is less convention rate under the Atrocities Act. Then the Parliament amended it, and they brought the Section 18A. Section 18A was brought in, and what does the Section 18A say? It brought in the status quo. Ante was restored. That what was the status of this law? What was the status of the atrocities law before the Supreme Court judgment? That was restored. So this is the whole discussion you need to know about the Article 17. Article 17, it talks about the abolition of untouchability, and untouchability can be done in many ways. It can be done by the actions, it can be done by the insult marks, it can be done by the provocation, and it can be done by the justification. For this, if you are found guilty of this, if you do any atrocity like that, you would be taken under the Atrocities Act. And if you are registered under the Atrocities Act, then the burden of proof is on you. You would have to prove that you are innocent, and it may take up many years to prove that. And also getting the bail is not that easy, because the judge will have to take, the judge will give bail on his account to you, and mostly judges will not do that. They will not try to do that. So getting bail would be very much difficult for you to get the bail if you are put under this Atrocities Act. So this is what Article 17 says. and this case went to the Supreme Court. The House Supreme Court earlier changed it, and there were protests against it. Then the Parliament came in. They enacted, or they enacted the law. They brought in the section 18A, and the status quo ante was restored. It was given the previous position what it used to have before the Supreme Court judgment. So this is about the Article 17. Now let's try to discuss Article 18 here, and then we will conclude our discussion. Let's try to discuss Article 18. What does the Article 18 say? Article 18 talks about the abolition of titles. Abolition of titles. You can't use Sir, Rai Bahadur, etc. at the prefix of your name. So these titles which were conferred to you by the before the independence by the British government, that you can't use. And also, what does Article 18 say? It says, no title should be given to anyone by state. The state cannot give you any title, except, state cannot give you any title except what? Except the educational and military titles. Except educational and military titles, other titles can't be given to you. With respect to this, there was discussion with respect to Bharat Ratna and other awards which are given. Bharat Ratna and other awards, whether it is constitutional or not, because they are given. So there was discussion about it, and it was finally highlighted that they are very much constitutional, but you can't use them as prefix or suffix to your name. You can't Padma Shri, Amir, or whatever your name is, you can't use that. So this is what this Article 18 says. Article 18 says now these titles are abolished if you had any before the independence. If any title was granted to you, these titles are abolished. No title should be given to you to anyone by the state. State will not give you any title except the military and academic. Then there was discussion about the Bharat Ratna and Padma awards, whether they are the titles, they are the awards, they are the highest civil awards. Originally only citizens were given these awards, but further it was they were given to the foreigners too. So there was discussion over it, whether they are also contained in it, whether they are constitutional or not. They are very much constitutional, but once you are getting this award, it does not mean that you will add them as a prefix or suffix. And also the Supreme Court's highlighted that we should respect the merit. We should respect the merit. How we can respect the merit? We can respect it by giving these awards to them. This is what Article 18 Clause 1 says. Now what does the Article 18 Clause 2 say? Article 18 Clause 2 says no citizen can accept the title from any foreign state. No citizen can accept the title from any foreign state. Suppose tomorrow you do something good in music, or or you do something good in your life, or something good with respect to the society, and tomorrow Britain government or some other government wants to give the title. They want to give the title of knighthood, or they want to give the title of sir. Can you accept that title? No, you can't accept that, because Article 18.2 does not allow you. No citizen in our country can accept the title from any foreign state. This is what Article subclause 2 says. Then Article subclause 3, what does it say? Clause 3, it says if there is a foreign national in our country and he is holding the office of there is foreign national in our country holding the office of the prophet, and the foreign state is giving any title to him. Foreign state is willing to give any title to him. For that, to accept that title, he has to ask the permission of the President of India. If the President will allow him, then only he can take the permission. If he is working in the office of the Prophet. So this is what the Article Clause 3 says. Article 18 Clause 4, what does it say? If you are the Indian citizen, you are holding the office of the Prophet, and the foreign state wants to give you the award. Foreign country wants to give you the award. You are the Indian citizen, you are holding the office of the President, office of the Prophet, or the government office in India. So if foreign state wants to give you the award, for that what you have to do, to accept that award, you have to get the permission of the President. So these are 4 clauses which are discussed under Article 18. Basically, what does it talk about? It talks about the abolition of titles. You know, in 1857, when there was the first war of independence, you know, who were the people who supported the British government? They were the Nawabs, they were the elites, they were the educated people. They supported India, and for that service they supported Britain government, and for that service they were given the awards, and so those awards stayed with them forever. After the independence, those awards got nullified, and their state cannot give the awards. And if you have done something amazing, you will be given the Bharat Ratna or Padma awards, but you can't use a prefix to your name. Except the educational and military awards, you know, only these exceptions are there with respect to the awards or titles which can be given to you. What are those titles? Military or academic. For example, you can add doctor, what is your name, or engineer, what is your name, because it is very much necessity to, when you will add doctor to your prefix, it will give us the idea that particular person is a doctor, and if anything happens to any person nearby, we can approach him. So that is also the necessity. Then in Articles 18 subclause 2, we discussed that if any citizen is given the title by the foreign country, you can't accept that. Then Article subclause 3, if there is foreign dignitary or a foreigner working in India, he is holding the office of Prophet. If the foreign country is giving him the title, then he has to take the permission of the President. Similarly, if there is Indian who is holding the office of the Prophet and is working in the government job, and the President and the foreign nation wants to give him any award, then he has to take the permission of the President. So this is what Article 18 says. So with this, I hope Article 16 is clear. Everything related to it, from clause 1 to clause 6, everything is clear. Article 17 is clear, and Article 18 is clear. With this, I would like to thank you guys for staying with me, and let me check if I had brought the questions with respect to 17 and 18. With reference to Article 15, we discussed these questions. In this 14, this is with respect to 13, we had discussed these questions. This is with respect to 12, and this is today's discussion. So everything we had discussed today, I hope you would have liked the video. I hope you would share it with your friends, and I definitely hope you would subscribe the channel. Thank you for staying with us. Thank you very much, and have a nice day.